The UK Supreme Court is hearing a legal challenge to the Scottish Government's plans to appoint individuals with a legal duty of care for every child in Scotland. The so-called named person provision would mean that one public worker, like a head teacher or a health visitor, would be appointed to look out for a child's welfare. Whilst the Scottish Government says it will be a safety net, others have opposed the scheme. Here's STV's Harry Smith.
It has already been the subject of hours of debate in the Scottish courts. Today, the named persons legislation began its route through the Supreme Court of the United Kingdom. Before a panel of 5 judges, a group of charities and individuals argued that the Act represents an unjustified state interference with family rights.
It is a fundamental principle of human rights and of a constitutional democracy bounded by the rule of law that the state is not the totality.
The legislation will mean every child in Scotland under the age of 18 will have a named public sector worker to look out for their welfare. The government argues it's in the interests of all children.
It is not to be assumed that the named person or other authorities with powers under this Act will overreach.
The Scottish Government say the legislation has already twice been approved by the Court of Session in Edinburgh, and they're confident it will pass this supreme test. The hearing is expected to last just one more day. The judgment will be delivered in a matter of weeks.
Well, joining us now from Edinburgh is Martin Crewe, the director of Barnardos Scotland, and Stuart Waiton in Dundee is a senior lecturer in sociology at Abertay University. Thank you both for joining us. Martin Crewe, why do we need this legislation?
We need it because it's an integral part of the new Children and Young People Act. What we're interested in is making Scotland the best place in the world to grow up, not just to wait until concerns about a child's welfare have escalated to the point where we have to make a child protection intervention. What we want to do is to pick up problems early and give help and support to families so that they can it doesn't have to escalate that far and they can get the help they need.
Stuart Waiton, why do you disagree with that?
Well, I think to start with, it's worth putting this in context. I think there are major preoccupations with child safety today, where there's discussion of something called the at-risk society or a culture of fear, where more and more things are seen as being potentially problematic or abusive. So smacking your child, shouting at a child and things like that are increasingly categorised as being problems, and even problems associated with abuse. And the family in that context is being seen as potentially more and more toxic. So there's an increased anxiety about privacy and autonomy in the family. At the same time, you also see what's been called a form of professionalisation of parenting. So there's a trend in all social policy related to this and in politics generally to think that parents need skills training, basically. So David Cameron came out a few weeks ago and said every parent, it should be an aspiration to have parenting classes. So these are two of the trends that are developing, and I think in that context you can see that the state guardian is it's like a kind of surrogate parent stroke mini social worker. Rather than being a teacher or a doctor or a nurse, you're now going to be a state guardian looking at a child in a very different way, in a very problematic way compared with how you might have done previously.
Martin Crewe.
Well, that's, I'm afraid the term state guardian is only ever coined by the No to Name Person campaign. This is not about a state guardian. This is about the health visitor who already works with the family. This is about the teacher who already knows the child in primary and secondary.
So Martin Crewe, if that's the case, why do we need this extra level then?
It's not an extra level. It's a articulation of what we already have in place. What it means is that we have a single point of contact, and it's worth remembering that the phrase the named person actually came from parents. They said that they wanted a single person who would know their child, and they can then coordinate support. What we hear from parents and children is that they want that support. This isn't some nanny state intervention that everybody is getting very worried about. The big concern for the 20,000 plus children who we deal with every year is that they are not getting the support they need.
Stuart Waiton.
The category that is going to be used for identifying problems is well-being. Right? Well-being concerns. So instead of intervening when you think that a child is at serious risk of harm, you have everybody now being trained about well-being indicators. And you look at these indicators, there's 308 of them. Well-being and well-being concerns can be almost anything in terms of does the child smile enough? Right? What is their relationship like with their parent? Does the parent respect them enough? There was even a leaflet put out that says, do you consult your child about what they watch on television? Do you consult with them about decorating their bedroom? So minor things are now going to become potential reasons for intervention. Right? And especially within a framework where I do genuinely think people will play it safe, then almost any professional that relates to children and parents will now be looking at them, having been educated about all these risk indicators, well-being indicators and so on, and you will change the relationship between parents and professionals.
Very briefly, Martin Crewe, we heard the QC for the Scottish Government saying that there would be no risk of overreaching, or there would be no overreaching. Very briefly, how can you guarantee that? Very briefly.
Well, I think we go back to the Court of Session ruling, which said very clearly, having looked at this issue, there is no legal, moral or social change to the relationships within the family. You can't get more definitive than that.
And finally, Stuart Waiton, the Court of Session has rejected it twice. How confident can you, as the opposition, be that the Supreme Court will reconsider, and would that be the end of it? Again, very briefly, if you will.
I've got no trust in law lords. I think parents need to campaign to get rid of this nonsense.
Stuart Waiton, Martin Crewe, thank you both for presenting your case this evening. Thank you.